You usually don't need a microphone. Oh, there it is. Very good. Good morning, everyone. Thank you very much for joining us for what undoubtedly will be the highlight of your IGF. This is the panel on mobile trust and privacy. It's particularly important to do this early in the morning because you don't get too excited as a result of some of these issues. This is the third time we've met, and our distinguished panel will answer the question of, among other things, what has happened in the intervening years to help extend the information society interest in being able to deal with data privacy and mobile services while at the same time protecting our rights and interests in privacy. We've got a terrific panel. What I've asked all of our panelists to do is to give a short presentation, only 4 or 5 minutes, so it's not even really a presentation, of a couple of points that they specifically want to make sure that they have gotten across to you all that they think is particularly important, timely, and the like. I've asked each of them to give a very brief introduction about their role within their organization and the relevance to this topic. And then we're going to be opening up for questions. We want to make this as interactive as possible, so feel free not only to ask questions, but if you want to make statements, have views and the like, please share them as well. Since the GSMA has organized this, and Pat Walsh has been the key driver of this, I'm going to ask Pat to begin, and then we're just going to go right straight down the dais. Pat?
Okay, thanks, David. Well, thank you for finding time to be here with us. It's much appreciated. David wants us to be controversial, so if I'm going to be controversial, not everything I say will be the view of the GSMA. So please don't write me off.
Yep.
So privacy, just a couple of stats. So there are 7.1 billion connections globally at the moment and 3.6 billion unique mobile subscribers. Now bear in mind, often when figures are bandied about like 1 billion Facebook users or however many Google users, that's one company. And these 7.1 billion connections are connected by 800 companies that operate in 219 countries. So it's privacy is an extremely complex matter. I think also I'm going to challenge whether or not privacy law can ever meet people's privacy interests and protect their privacy. So we did research on 11,500 people in 800 countries, and the documents are at the back of the room there. And it's very clear to us that trust really matters, and that 82% of people want to know what data is being taken from their devices, and they want to be able to permission that. And 60% of those surveyed, just in the area of location alone, wanted consistent rules to apply. Now, just think of this consistent bit when I talk in a few minutes. So for me, privacy in mobile, everybody is moving to mobile. Businesses are waking up to mobile. I hear Google, Facebook, everybody saying it's mobile first. And that's true. Governments want to use mobile to provide the key means by which you will access government services, for example. And it's absolutely terrific. I've seen mobile deliver so many opportunities to people around the world. But in mobile, it's very different. Mobile has traditionally been regulated by a precautionary principle. And this began in the mid-90s, where they felt that there were harms that could materialize in the privacy sector. So they regulated by particular rules. And yet, we have to ask ourselves, I think, in a world of converged services, whether such an approach is really applicable today, because my privacy is affected in many different ways in the context in which I use my mobile, and by not only the operating system, by the hardware manufacturer, by the platforms, by the app developers, etc. This is a key issue. And I think the other thing that affects the ability to provide a privacy protective experience in mobile is the fact that not only is mobile affected by omnibus data protection laws where they exist, but there are also telco-specific rules, there are license conditions, there are codes of conduct. It's actually really fragmented. If I look, for example, in mobile, some of the abilities to provide privacy protective experiences are hampered by license conditions, some of which might require an operator to obtain prior approval to deploy bulk encryption on their networks. some of which require them by law to maintain obligations to lawfully intercept communications. Then we may have SIM registration programs. One country recently issued a direction to operators to deal with the theft and loss of stolen handsets. So we have a system whereby we can block those handsets from being used using your IMEI. But in this particular country, a direction was issued whereby mobile operators have to send names, addresses, national identity numbers to this government database. So whilst we make every effort to improve trust and privacy in mobile, it's sometimes distorted by regulation. And I do find that regulation is distorting a market in privacy, and it's distorting the market in data as well. And I think it's time for me, there was a workshop yesterday that talked about privacy engineering, and that's really important because for me, and I'm aware David is one of the best lawyers, that the law will never do this. It won't do it. So I am currently trying to do some initiatives in countries where there are no laws. So it's as much a cultural challenge in those countries, convincing companies to do the right thing, to be responsible, and to establish the right standards and approaches to this. And so privacy engineering is a key concept. We hear about privacy by design, but that's still a bit sort of woolly for too many people, but privacy engineering seems to be something tangible. But how do we engineer for privacy both in law, in hardware, in software, in platforms, and in apps? Because all of these come together. One final thing, if I may, this is the IGF, and privacy on a mobile device is affected by telco regulators, what they do. They have a say in how privacy is regulated, by data protection, privacy commissioners who have a say, and by justice departments. But I don't see a forum by which all of these different, and I'm not going to use the word, interested parties are brought together to discuss these things in an open and transparent manner. And I'll talk about some of the things we're doing as solutions later.
Thank you, Pat. Before moving on, let me ask a quick question if I could. So the underlying theory is that privacy is important. As your survey data indicated, it's extraordinarily important to virtually everyone. Why are we seeing, and if not, why are we not seeing more competition amongst app providers, carriers, and others to provide greater privacy protection for consumers as a marketing tool in order to get more customers?
I think privacy, I recently gave a talk to a group of people about moving from privacy as a chore to privacy as a value and opportunity, because privacy is a chore for consumers, for users, for citizens. It's a chore internally. As a chief privacy officer, when you try to deal with your business departments, they see you not as a CPO, but as a PPO, a project prevention officer. So again, you've got that challenge. But there is very real value here. But I think you mentioned platforms and app stores. Actually, some app stores won't allow certain privacy protective apps on their stores. So it's also a fallacy to suggest that the markets in some ways can always take care of this issue.
Alex?
So as part of this panel, we're asked to highlight some of the challenges and some of the solutions, or at least the work that we're doing to try and address those challenges. Well, first of all, Privacy International would like to thank the organizers for asking us for the second time to be on this panel. Mobile telephony has brought so much power to individuals, enable them to speak, to engage in civil society, in politics, to learn, and to have an outreach to a wider world. But this power hasn't only been taken on by individuals, unfortunately. The governments and industry have used mobiles to get an insight into individuals, their lives, their friends, their families, their networks. I'm going to quote actually former vice president of social on Android from Google, who once said, "A mobile phone has ears, has eyes, a skin, and knows your location. Eyes because you never see one that doesn't have a camera, ears because they all have microphone, skin because a lot of these devices are now touch screens, and GPS allows you to know your location." But what this quotation fails to acknowledge is that your phone is betraying you by sharing information with or without your knowledge, and this is increasing concern to users, as Pat mentioned in his presentation. before getting into more of the details, I wanted to just give a broad highlight of the context in which we're having this discussion in terms of the legal framework in which this is happening. Some of the time there isn't even a legal framework, either because there's no data protection law in place, or just as well because the rule of law is not respected in some countries. Nevertheless, we see that in around 101 countries, and I think South Africa was the last one of November to adopt a data protection law. But nevertheless, there's still a lack of legal frameworks around domestic communication surveillance practices and policies. The second one, in terms of the legal framework, I wanted to mention, because it's increasingly becoming popular, is to adopt data retention policies. And our argument is, if there was a strong and robust and respected data protection law, there wouldn't be a need for a data retention policy to complement it. Then going into more of the details, I wanted to highlight two actors, set of actors that I think are the main ones that are engaging in this industry, in this sector. So first we've got the industry, and now by industry I mean telecommunication, internet and network providers, information and technology and service providers, but also device developers. So looking at them as a broad actor, and we can disagree that they have different responsibilities and obligations, and they have different purposes and different business models, but at the end of the day, all of these actors are collecting, using and storing and sharing users' information, and this is why we've categorized them together. We welcomed the approach and the new initiatives from the industry to publish transparency reports. But that's not enough. Transparency is not enough. Transparency is the final step of a multi-step process that includes pushing back on surveillance laws with the same vigor that industry is pushing back on privacy laws. The second is protecting users, collecting less. There's increasing amassment of metadata that can be argued that is not necessary for the business model that companies are trying to implement. It's not necessary for them to deliver their services to users. The second one is to push back against government requests, and we've seen some companies doing that. The third one is to protect and follow data protection law, to be transparent about the data protection laws under which they're operating. The fourth one is more on a technical level, and I think we shouldn't forget that, is to secure the platform and services under which these are operating. And the final one, like I said, and it is in this order that it should happen, is to be transparent, including about the legal framework, but also specifically about the relationship that companies and the industry in general have with law enforcement and national security requests. The last actor I wanted to mention, and this can be controversial because most of the discussions people might expect to be about the industry and companies themselves, but the state. I want to bring in the issues that we've been having for a long time, and more particularly and more visibly in the last sort of 18 months. Industry can do what they can to reassure their customers, and they should continue to do so. But we know, and we've seen from the Snowden revelations, that increasingly there have been external interception technologies being deployed by states. And by that I mean that the telecommunication networks might not even know that the states is interfering and having access to their networks. The NSA and GCHQ tapped directly into internet and network service providers' systems and infrastructure to obtain data. They hacked into Google's communication infrastructure as well as others. And this is something that we're challenging in the UK courts at the moment with other civil society organizations. And the point I wanted to make by mentioning the role of the state and in terms of the way that people engage in respect to mobile technologies is this goes well beyond lawful interception of communication. And what will that imply for the trust that people have in using these systems? And as the industry, somebody has joined us. And as the industry, it's really something that we have to address together. That they are bigger adversaries And in terms of the solutions to addressing this problem, is we suggest the 13 principles, and I know they've come up several times this week, and they might seem like an abstract contribution from civil society, but for us it was a way of consolidating all the protections that currently exist on data protection, privacy, and surveillance, and to gather them into a list of principles that are approachable and can be implemented by all actors. So we can go into more detail.
Terrific. Before going to Amos, who has joined us remotely, and knowing how tentative all of these connections are, Pat would like to jump in. What we're going to try to do is get as many of the panelists to ask each other questions as well. And Pat is chomping at the bit to comment about something Alex said.
Well, I'm not going to touch on the government stuff because I'm sure we'll have much debate on that later. But it was something you said about respecting data protection laws. But many of the countries that our members operate in don't have data protection laws. As this is a cross-ecosystem issue, how does Privacy International feel you could bring industry? How can industry come together and agree on what standards should apply? Because after 5 years, somebody said to me, it's like pushing a rock up a hill. Actually, it's not a rock, it's a boulder the size of a house.
You're on. You're still on. You were. No. Yeah, no.
No, definitely, and it was one of my points for later.
Sorry.
No, it's fine. I mean, it's definitely one of the challenges we're facing, but we really feel that that is the starting point, is to establish laws. And we work with different partners across the world, including CIS, who is present on this panel, and I hope Sunil will back me up in a minute in his presentation. But for civil society, there are milestones to reach, and advocating for data protection laws is one of them, and it is a long process, and we haven't achieved it in all of the countries, but it's a starting point to raise awareness about what the issues are. For example, something that we might start implementing in, and I know some of our partners are thinking of it, is with the new EU directive on data protection and the regulation. This includes a provision where the EU member states will not be able to do business, to engage with countries that don't provide sufficient standards for data protection. So, I mean, it's all political, but that's something that we know people will start using in their advocacy to convince their governments that there's a need for it. And it's maybe more from an economic perspective, but it will benefit the protection of the privacy.
Terrific. Amos, if you can hear us, and it looks like you might be able to hear us.
I can.
Terrific. We have this group has a very bad track record of doing remote access here. It is the Internet Governance Forum here. Amos, can you give us 4 or 5 minutes and be prepared to answer scathing questions?
Of course, yeah. So just a brief introduction. I work with Axiata, which is an Asian telco group, and we have telcos in 5 different countries. Malaysia, Indonesia, Cambodia, Sri Lanka, Bangladesh, and interest in telcos in another couple of countries, India and Singapore, a minority interest in those companies. So we have to cover 7 regulatory environments, some of which are normalized in so much as, the way telcos work is relatively normalized, but some of which aren't, in terms specifically of local considerations for data protection and privacy. And the project I'm working on at the moment is actually a group-wide project to actually link all of these operators up with an API layer. So I'm going to attack this from a slightly different problem. I've got serious practical problems, not only about the fundamentals of privacy and data protection, but also with the local nuances. So I'm struggling from a technical point of view with those nuances, trying to anticipate what one might need to do, for example, in Indonesia, which thus far one doesn't need to do in Malaysia, for example. And I'll go into that in a little bit of detail in a minute. But before I get into those sort of specific issues, I think one of the things that we in the sort of telco space see is how difficult it is to operate in the over-the-top commercial environment when the over-the-top commercial environment is seemingly relatively unregulated and therefore, is aggressively commercially driven. And in an environment which we're in, which is actually relatively aggressively regulated, and it actually makes it quite difficult to keep up. So one of the problems that we have specifically in relation to privacy and stuff is that you'll find, the telcos are sort of pushing the limits to some extent. It's actually often to do with commercial pressures of keeping up with, keeping the revenues coming in, tactical advantage on a month-by-month basis. And so I think from time to time you'll find that telco services are pushing the envelope, and obviously some of the issues around SMSs and the way they've been misused over the years is a good example of that. So I think that's one of the issues that we struggle with. And in fact, I think there is potentially an opportunity for telcos to regulate themselves back into the game in that respect, because I think that there is a requirement for privacy to be more controlled. And there's an opportunity, in fact, for telcos to take that, to take the high ground, if you like. And there's certainly one or two GSMA initiatives which are going in that direction, and I think they're good ones. But on the other side of the coin, there's a lot of organizations these days that are putting together services to help the customers take control of their identity, for example, and take control of how their data is distributed and on what basis it's distributed, etc. And there's some companies that are actually putting together services that will allow customers to actually potentially benefit from, actually make money from sharing their data in a controlled way. And I think that's a good thing. I think it's a commercial opportunity. And in the end, I think this is going to be commercially driven to a great extent. So I think that's one of the issues that we face. I think that from a technical point of view, we may find that how can I put it? Some of the new services that come up to serve customers better will be driven by local regulations. So, an example of some of the issues I'm facing, the services that I'm putting together now are cloud-based, but some of the data cannot leave the country. And so we're having to effectively come up with hybrid solutions to ensure that we comply with regulations by sticking any data that, or keeping any data that is generated from the customer in country and then anonymizing it when it goes into the cloud mediation layer, if you like. And that's quite a challenge. One of the other challenges is that if some of the service providers that we use are based in countries which have very draconian laws, related to being able to access other people's data, that causes us a problem. And we're actually having to consider where a company's based when we're thinking about which vendors to use for services that may be cloud-based. So that's another issue that we're facing at the moment. It's a fairly contentious one. Obviously, the NSA conversation is fairly current. But that's becoming a procurement consideration when it relates to data customer privacy. My personal feeling is it is an opportunity, this subject for telcos. My personal feeling is, and this isn't an anti-alpha feeling per se, but it's certainly something that I talk about quite a lot within my role, is that we have an opportunity to do something about it and take the high ground and potentially start to help protect the customer in their, interfacing with various web services, etc. So that's pretty much where we're coming from.
Thank you very much, Amos. Let me ask you, you talk a little bit about the potential for taking the high ground for the telcos and so forth. Does that mean that you also think that there's opportunity for competition in this space, that is between and among telcos as well as competition with OTTs and others?
It's a really good point. I mean, I think one of the things that sort of telcos, you know, I think they realise, they recognise, is that there are certain points beyond which it's going to be very difficult to go. Telcos are fundamentally a utility. They're a very important utility. They're an integral part of everybody's lives. There's one or two, you know, there's one or two areas in which I think that telcos can sort of increase their position in the ecosystem. And one of those is, in fact, you know, customer privacy, customer data. And again, there's some initiatives that are happening there. But I think it needs to be across all opcos. I think there needs to be a raising of the bar of brand mobile rather than specific telcos competing against each other in that particular area. I just think that when you get a mobile phone, you should know that it is a very secure device. It's a device that can help protect your privacy. It's a device through which you can mediate your own data. And I think that would be a service that telcos should be providing generically across the board. I also think there's going to be significant competition from OTTs to try and take that space themselves. But I think it's actually a natural fit with telcos. So, you know, if you like a trust mark associated with your friendly local mobile operator. I also think because telcos are local by nature, even though there's lots of ability to roam, that's an advantage because you've got some fairly large and fairly aggressive OTT companies that are global in nature and therefore don't necessarily have local presence or the ability to act, you know, in a very local way. So again, I think it's quite a natural fit. But I also think customers would benefit tremendously if that was the case, because I think there needs to be a separation. I think the concept of identity and the concept of those things which you'd like to attribute to identity attributes is something that is going to become a very, very important part of people's lives.
Terrific. Thank you very much. Sunil?
Good morning. My name is Sunil Abraham, and I work with the Center for Internet and Society in India. 5 years ago, we had no idea about the importance of privacy, but thanks to a partnership with Privacy International, today we are best known for our work around privacy and data protection. What I will try and do is, in a telegrammatic fashion, try and quickly address all the questions that were posed to the panel. The first question is, how can citizens in both developed and developing countries benefit from the responsible use of mobile data? Telcos, as you know, are sources of big data, and what would be the need of the hour are norms around the use of big data. I will use one example to illustrate. LearnAsia got anonymized call record data from all the telcos in Sri Lanka, and then were able to test a thesis whether people from North Colombo came to South Colombo as part of their daily life, and whether the opposite was also true, so that the transportation system in Colombo could be engineered more appropriately based on this divide. Second question, what are the key emerging issues and challenges of a mobile, hyper-connected world? I think more and more people accept that privacy and national security is a false dichotomy. More and more people accept that what we need to do is optimize the national security imperative and the privacy imperative. At CIS, we are working on one solution, which is encrypted logs at the telco and ISP level, and key escrow for every single mobile user with the Privacy Commissioner or some other human rights commissioner. There are also very interesting papers, for example, a paper by Dr. M.M. Oberoi on how to design a fishing expedition with minimum impact on privacy. How can we ensure secure and trusted identities online? Here I will use the example of the Indian UID project. It used to be, or is still in some senses, based on biometric standards. The trouble with using biometric standards are that it is irrevocable, proprietary authentication and identification, and a centralized topology. We have been advocating that we should shift to digital signatures, which could also be on the mobile phone. Here we would have revocable authentication factors, completely open software and standards, and a decentralized topology. What needs to be done to ensure consumers are able to access services in a private, trusted, and secure ways? Apart from the obvious answers, such as open hardware and free and open source software, it would be excellent in the post-Snowden era if we can address all the concerns around cryptographic standards that depend on elliptical curves by getting governments across the world to throw $10 billion at the problem and create market incentives for investigating, researching, and fixing cryptographic standards. What are the different roles for law, industry, self-regulation in enhancing trust? The way Pat has posed the problem, he says that no law will do it, and he says that countries don't have data protection or privacy law. And now I'm going to commit a sin. As per the norms on this panel, I'm going to use the bad word, the multi-stakeholder model. In my view, the multi-stakeholder model is nothing but open and consultative self-regulation. It is nothing else. And what it does is allows industry the opportunity to preempt regulation through hard law and mitigate harm and uphold the public interest. And we have an example of this happening in India. Since the government in India is not willing to discuss the privacy bill as it is being developed, not yet willing to place it in the public domain for debate, we have come up with a shadow bill, and we are running a shadow policy consultation process. And since we are occupying this vacuum in the policy space, more and more industry is beginning to assume that the real bill is going to look like our bill. And most recently, we got calls from a telecom industry consortia, and they want to have a discussion on us on this fake or fraudulent bill. And if they self-regulate, then it reduces the reason for, reduces the rationale for extensive and perhaps inappropriate over-regulation by the government. Thank you.
Terrific. Talking a little bit about what's going on in India as one example, how much of this is being driven by what is happening domestically in India, as you point out, things like the privacy bill and the like, versus those OTT services from companies outside that have no connection to India, but yet provide services to people in India? How do you, that's a challenge, how do you see that playing out?
So there are perhaps three imperatives for privacy policy development in India. The national security imperative became obvious only post-Snowden. Prior to that, because of large projects like the UID, human rights was an imperative for developing privacy policy. So the privacy law that the government is working on is happening simultaneously with the development of the UID project. And the second imperative for India is trade imperative. A lot of personal information from developed countries come to India because of our large outsourcing industry. And in order to protect that trade, we must have robust and robust privacy law that is compliant with international standards. Thank you.
Terrific. Let me just warn everyone here in the audience that I'm going to be going after our next speaker to you all for statements or for questions. Titi?
Hi, everybody. My name is Titi Akisami. I work on policy and government relations in general for Google across sub-Saharan Africa. and I am going to be as controversial by putting the very controversial issues right out there. I want to be able to make a couple of very clear statements that if you take nothing else away, once we've started the debate, you're very clear on where we stand as Google. One is the fact that free flow of information is important. It is culturally, economically, and socially critical. Third is the fact that free expression is critical to who we are as Google. I will speak a bit briefly on surveillance, on the right to be forgotten, and I will end on a couple of notes. But before I go, as part of my slightly being controversial, I'm really curious to see that there's nobody from the telcos on this panel. It would have been interesting to be able to give them some space to be able to engage with a lot of the questions that have been thrown of them. On surveillance, one, laws around the world currently, they do not allow governments to access, in general, private information, but they need to be a lot stronger than they currently are. Second, we think it's important to be able to explain how often and how governments are able to use the laws at their disposal to gain access to end users' personal information. Currently, that is not very clear. Third, lawful access must be under due process. We're aware that the MLATs don't currently meet that greatly, but I think that's something that we're currently working on. Why am I speaking about this in a mobile? At the end of the day, having a lot of access online on traditional media is exponentially different once you bring the mobile factor. And I see that personally as well, that begins to open up a lot more conversations. On my continent, for example, I think very few countries actually have data protection laws. Where there are no data protection laws or data protection agency, it makes it a lot more difficult for us to be able to do our work and protect our end users. On right to be forgotten, we think it's an impossible position. It puts it in a very, very difficult position to balance an individual's right to the public's right to information. We certainly disagree with it, but we are implementing it because, again, we have to operate within the rules of the law. We are implementing it in a very focused way and within the confines of a very broad and very vague ruling. We're doing our best to be transparent. I hear very clearly from Alex that transparency is the last step of the law, and we have tried to follow through on every single one of the steps that you have mentioned. The concern, though, is that consistently, private sector should not be leading by itself this entire process, but rather it should be a collaboration across the ecosystem. Where was I now? Okay. To just finish up, because I want to be able to take the questions, is one, we'll continue to act responsibly. And acting responsibly sometimes means that certain constituents will feel that they have been left out or they have been, that we shouldn't be doing what we need to do. Second is the fact that we don't have all the answers. Google certainly doesn't have all the answers, and we are very clear. Instantly in my head, I went, oh, you're supposed to be able to Google anything and find all the answers. But unfortunately, we do not have all the answers. But we're consistently working with a range of parties to be able to get to that point where we can engage a bit more. Going to leave it open so we have more discussion. We have...
So Neil?
I can see.
Since Google doesn't have all the answers, I thought I would provide them with some. Apparently,
Thank you.
Apparently, people think it is difficult to optimize privacy and free speech, more particularly the transparency component of free speech. As an engineer, I have reduced this to a mathematical formula. Privacy protection should be inversely proportionate to power. Transparency requirements should be directly proportionate to power. In both privacy law and in transparency law, the phrase public interest exists, and this test allows us to asymmetrically distribute protection or requirement across an society where there are deep power asymmetries. So it should not be difficult to think that through. I think Google in some ways is trying to only adhere to the letter of what the European Court has said rather than the spirit, and in some ways trying to demonstrate that it won't work at all by implementing it poorly. But if Google takes this seriously, that both free speech and privacy are equally important rights, then the letter of the law already tells us in some way how those rights have to be balanced. Thank you.
Let me assure the audience that despite the fact that there's been an equation used today, there will be no examination before we leave. Before going to Pat, let me ask a question to the panel that was just raised. We have the right to be forgotten coming out of Europe, and yet Sunil was just commenting on that generally. Do we see that as a trend globally, or is this a one-off, just a European phenomenon?
Okay.
Sorry, TT. So the Hong Kong Privacy Commissioner has said that Asia needs to consider a similar right to be forgotten. So it is having repercussions around the world, and it's not a right to be forgotten, really. Let's stop using that term. It's a right to have your data deleted. And in the UK, you've had such a right under the existing Data Protection Act for many, many years. It's just a bit more challenging in Google's context. But I wanted, if I may, David, just to touch on something that TT said, which is that laws in general don't permit access to private sector data. That may be the case for Google and Facebook and others, but it's not the case for telcos. Generally around the world, there are laws and there are license conditions and other things that place obligations on mobile operators to provide assistance. And then in relation to transparency, just to pick up on that point that has been made by TT and by Alex, then in the example that I mentioned earlier, where this particular ministry has issued a direction against mobile operators requiring them to send to a third-party database the IMEI, other identifiers, names, addresses, dates of birth, national identity card details, etc. There's no overarching law to regulate the investigatory powers of the state in relation to access to that. So in terms of transparency reporting, that obligation should be on the state and not on anybody else, because this data is having to be sent for every customer.
TT, do you want to?
Yes, on the right to be forgotten, I actually wanted to say that we actually have seen a proliferation, not just in Europe with the ruling, not just in Asia, but also in Latin America, and interestingly in a few African countries, where laws that have been loosely defined previously are now being reinterpreted to be a right to be forgotten. Now, like we said, it is about finding the balance between the freedoms and the responsibilities. And what we are saying is that we should not be put in that position to find that balance alone, but rather it should be a collective. Otherwise, we are going back to, I've been in these conversations around internet governance for about 14 years now. We're going back to that place where intermediaries are being placed in the role of the judge, the judiciary, the prosecutor, the advocate, and it should not be, that should not be sitting in the hands of the private sector.
Any other comments before we go to the audience?
I completely agree with what she said. Both on free speech and on privacy, intermediaries should not adjudicate and make the decision. But on the other question that you asked, on whether this is a global concern, perhaps not. In a country like India, where we don't have sufficient basic privacy and data protection measures in place, or law in place, then moving to some of what we might consider rather advanced rights is perhaps too premature. It might lead to too much regulation of the industry, and that might not be appropriate.
Let me look to the audience for some questions. Chris, I think you looked like you had one. Let me get you a microphone here.
So this is sort of in combination mostly for Pat and Alexandrine, but others are welcome to jump in. I appreciate the point on the market here, and Pat, your sort of theory that law has its limits. I would say, isn't there a role at minimum in policing honesty of consumer-facing claims of privacy, and sort of corresponding to that, a minimum of transparency in making those claims? Just because both of these, if they're not strong enough, really limit the effect of market forces. And then segueing into government issues where market concepts really aren't salient at all, because you can't realistically choose your governments. There is a long history of collaboration between telcos and governments. I can accept the premise that there's value in that, doesn't mean that there don't need to be good legal limits on scope and substance. But Alexandrine, your point about transparency coming last, I think, is very relevant in trying to get to substantive checks. But to me, it also really has to come first. Because in democratic societies, we all too often don't even have insight into what the relationship between the telcos and the governments is. And so we can't effectively push for change on that. So would love thoughts on that.
All right, who wants to begin? Looks like Pat already has his finger on the button. Go ahead, Pat.
So, so I should have qualified it. So when I talk about law, and say the law can't always do it, so I'm thinking in terms of consumer law and transparency, notice and choice, and some of the usual things that we have to deal with. Because some of that law is also premised on, for me, an increasingly outmoded concept of personal data as being something which you can identify somebody from, but in today's hyper-connected world, that's increasingly irrelevant. You don't need to know that it's Pat for you to be able to track me and have consequences for me. In relation to government, let me make it absolutely clear that it is my view, and I'm not speaking on behalf of the GSMA, but there is a need for transparent laws. There is a need to set the expectations of citizens to the circumstances under which their privacy will be infringed. And there needs to be very clear, justified, proportionate laws that regulate the investigatory powers of the state. And there are other things that are being done that sit in ambiguous areas of the laws. And the law should be explicit about whether, for example, certain capabilities and technologies can or can't be used. So that's my view. Please don't quote me as the GSMA, but that is my view. And I should say that that view is based on by the way, that not just because I was a chief privacy officer with mobile operators, but I used to run teams that did government interception and disclosure work. So I have two hats. And it is very clear to me that there is a need to address this issue.
Other comments?
I wouldn't mind making a comment here.
Okay, go ahead, Amos.
I think that the degree to which governments and telcos collaborate is obviously high, but it's also high because of the degree to which telcos are regulated in the first place. And the products that telcos present to customers are a result of that collaboration and all those regulations. The second thing is that telcos traditionally maintain ridiculously large customer care centers, which most of the OTTs simply don't. So customers have huge recourse and can actually change what telcos do if enough of them can complain. I would suggest it's almost impossible to do that with a large OTT. The second thing I wanted to say was that I just don't buy self-regulation. And that's just a pragmatic statement. I just don't buy it, because at the end of the day, the market drives, and people will do what they can get away with within their current interpretation of the law. So I just think that at some point, we are going to need to find ourselves in a position where there is some central regulated entity, whatever it is, that can help solve this problem.
All right, well, Amos just went the other way from multi-stakeholder to government regulation. We have a comment over here. Before, was there any other comments? Sunil, did you have a comment? Oh, Alex, did you have a comment?
To respond to Chris, the way we presented it was to have the transparency report as sort of the last step, to show that there is a multi-step process, and I was happy to hear that Google takes that approach as well. No, definitely there needs to be transparency from the beginning, and the way we see that element of transparency is to have access to the laws that regulate the relationship between telcos and the state, because at the moment we're engaging in an environment where a lot of the relationships are done through secret laws, and for us secret laws are not law. So.
Very good.
My name's Louise Bennett from the BCS. I think there's a danger that we might be confusing privacy, which is about revealing personal information only to those you choose, with data protection, which is about protecting personal data that an organization has been entrusted with. And I don't think these are the same things at all. In the survey that you produced, you quite rightly said that most users don't do anything about their privacy settings, although they want privacy. And that is because the industry, all parts of the industry, seem to have much too complex privacy policies that are unreadable to the ordinary person. If the industry self-regulated by having privacy by default as a setting, this would go a long way to engendering trust in consumers. I also think that some companies, and I'm afraid I include Google here, think that privacy is about sharing things between the individual and the company who you've first given it with, which it's not.
Comments? Obviously, we're going to go to TT because she's calling out Google here.
Yes, 100%. And we're okay with being called out. I think post-Snowden or pre-Snowden, a lot of the approach, and I'll use the example of Gmail, has always been about giving the end user the opportunity to be able to choose to either encrypt their mails or not encrypt it. Post the Snowden revelations, as a rule, we took that away and we made sure that once you're sending an email, it's encrypted. On the one hand is the fact that end users, consumers, whatever you want to be able to call them, are not necessarily as aware as they should be about the extent to which the information can be accessed. So a lot of what we have done and we have ramped up is making sure that our end users are a lot more aware. The point around making the privacy, the terms and conditions, the terms of service a lot more clear and simplistic, such that a regular end user can understand it, is also something that we are taking on board, and we are putting in a way that we can have simplified conditions in place. But I wanted to be able to track back to him mentioning the consumer, and a bit more to your point that in the entire ecosystem, sometimes we forget that even if there's regulation, even if industry is doing that which is right, if the end user is not as aware of the power of the technology in their hands, they will still make wrong choices. So a lot of the work that has to be done, if you can make the right, if there's a lot more education that can be done for the end user to adopt technology. We're putting mobile phones in the hands of people who are living in remote areas, and their core concern is about being able to use it for economic reasons. Top of their list is not necessarily privacy, instinctively. So how can we best put that in place? And that role cannot always be played by industry, but sometimes by civil society. So I think we need to be able to find that balance as well to address that.
But isn't the point not making a business out of wrong choices?
Okay, sorry, Amos, could you repeat that?
I'm saying, isn't the point not making a business out of people's wrong choices?
All right, right. Sunil, you wanted to comment?
Just to reference some research from the Philippines, which basically tested a variety of respondents by sending the standard message, which is, can I make friendship with you? I'm kind of caricaturizing the message. And what was found is that people at the bottom of the pyramid with limited social networks would like to make more friends, would like to sacrifice their right to privacy for a right to publicity in a sense. And as you go to the top of the pyramid, and people already have extensive social networks, then they begin to value the right to privacy over the right to publicity in a sense. So it is almost impossible for a social network to address this very diverse set of concerns. Before I end, I'd like to point out that Professor Rohan Samarajiva is in the room, and the project that I mentioned from his think tank about using CDRs to do urban planning, perhaps he could tell us a little more about the project.
Rohan, he was talking about your Colombo project. Was there any more comments on that, Pat?
Just to come back to that, you're right. There is a difference between data protection and privacy, and that's kind of the point I was making earlier, is that if you do this from a compliance perspective, which is complying with data protection laws, you're never really going to address privacy or delight your customers. And this is as much about designing for trust as it is for anything else. And in that research, I don't think any person would have thought that that was about data protection. The people that were responding thought it was about their privacy. And what we find around the world is that even regulators and policymakers are basing decisions without even conducting research into how people feel these days. And as I said, on data protection, you might have a piece of law that defines personal data as something from which you can identify someone from, but then you have a bunch of technical data and capabilities that in context, and when you merge some of this data, can reveal quite a lot about an individual. For example, it could put you, whether you're outside a Jami Masjid, the mosque, for example. It could put you outside whether you go and buy something in a halal store. Now you can begin to infer things from people about this data, even though strictly speaking that's not personal data. And one of the differences we have here, of course, is that while Google may have that level of data also, it's not regulated as telco data is. So my point is here, what is it that we are seeking? What are the privacy outcomes we want for individuals, and what are the risks and harms that we are trying to mitigate? Because the precautionary principle doesn't work. The precautionary principle does hold back innovation, and we have to find a different way. And I know Rohan sat at the back and probably wants to come into this. So we have been working on using mobile big data as well, and it's unfortunate that I couldn't get to Rohan's event, where mobile CDRs, even going back to Haiti, who remembers the earthquake in Haiti? That mobile, anonymized mobile data was used to understand where people had migrated to save lives. It was used to understand and help prevent the spread of cholera, because an aid worker took cholera into Haiti where cholera was unknown prior to that. So mobile derived data has huge social benefit. It has huge benefit to solve some of the most pressing public policy objectives of our time. And we have to find a way to use it in wise, responsible, trusted ways. And that's partly what Rohan has been doing.
Any comments or questions? Oh, Rohan's already coming to the front here. You've been called out.
Okay. Thank you for this opportunity. Is this on?
Should be. Good. Try it again. Here, switch.
I'm the chair of an organization called Learn Asia, which is a regional think tank working on ICT policy and regulatory issues primarily. And I happened in my previous academic life to have worked on privacy issues for about a decade, and primarily on transaction-generated information, as we used to call it. A guy called Thomas McManus coined the term. I think the more accurate term is transaction-generated data. So what we did is, as you know, there's a lot of buzz about big data everywhere. And Google data, bank information, payment information, etc. In the developing world, datafied data sets are very rare. So if you're looking at supermarket information or credit card information, you're going to get 5–10% of the population. But the only comprehensive data set that covers the poor is mobile big data. And that is our focus, my organization's. So on an experimental basis for pilot investigation, we obtained anonymized historical data sets from multiple mobile operators in Sri Lanka to address public policy concerns such as those affecting transportation policy, urban planning, and so on. I think I saw the traffic jams here, but believe me, in developing Asia, the traffic jams are something to behold. Entire cities are locked down by the independent actions of individual people, and nobody moves. So I think it is very important that we develop solutions for this, not on the basis of building more roads, but on the basis of using the potential of data. So we have done this research, and I think I don't have the slides with me because this is all about visualization. You have to show the slides. If anybody's interested, it is all on our web. We have presented it. It's publicly available on the web. You can look at it. The part that I think is of relevance to this discussion is that in the process, we developed a draft document, a draft guidelines for the responsible use of mobile big data by third parties for public purposes. And we are in the process of consulting with multiple parties, particularly those who have direct authority over this data resource, which is the mobile companies. And we are involved in discussions with mobile operators from 4 countries. at the CXO level. And I know that the CEOs are directly looking at this document. And instead of trying to put this data into the straitjacket of the inform and consent model that I am fully informed about, and which I believe was developed for credit reporting and tick boxes, which cannot apply to transaction-generated information, we are trying to develop a set of remedies, set of guidelines to remove or address the harms that could actually be caused by this data. Now, I will stop at that point, except I want to make one response to what Pat said, which is that in this kind of situation, if people are if they think that from anonymized historical data, you can identify who is standing outside a halal store, it just shows that you really haven't worked with the data. We are talking about millions of records a day. We are talking about the law of large numbers. We are talking about the fact that, in fact, the base stations give rather imprecise location information. I'm talking about feature phones, right? I'm not talking about GPS-enabled smartphones. They give rather imprecise location information. And it would be, I can barely differentiate between a pedestrian congested public transportation hub and another place where the cars are stuck in traffic, which is half a kilometer away, given the data. So why I bring this up is that it's very, very important for anybody who's going to try to regulate or come up with rules regarding big data to actually get their hands dirty. This is not for people sitting in air-conditioned rooms trying to spin hypothetical scenarios. There were things that I thought were problems, were feasible, were doable, that I found could not be done once we looked at the data. I'm not saying that what we have seen is static, that it will remain forever, but there are certain limitations to what the data can yield, and we have to be aware of the technical capabilities before we try to legislate on this subject. Thank you.
Terrific. Pat, you need to respond.
So I do need to respond to Rohan, because context is always important here. So the halal scenario is kind of different to what you're talking about, because where mobile call data records, CDRs, are being used in these contexts, they're generally being used in an anonymized way. Orange did some fantastic work in Côte d'Ivoire, where they used it for about 7 different reasons and released that data to researchers around the world under very strict conditions and rules. So that's kind of different, because what Rohan is talking about anonymized data, the scenario I gave is where it may be, for example, that my location data is held in a profile with lots of other data. You don't need to know that it's Pat. But actually, when we consider that governments have access to some of this data, and you know that it can be used to differentiate and distinguish between individuals, then these are things that we can't just ignore, Rohan, that have to be addressed. And in relation to the anonymized CDRs, then the UN Global Pulse has just established a privacy advisory group to look at what rules should be in place. I sit on that, and a number of regulators who are technically competent from around the world also now sit on that, and hopefully you'll see some movement, and hopefully Rohan will be part of that process as well. Because the thing that I notice here is that, and that concerns me, is that we don't have a standardized approach to, when we talk about anonymized CDRs, Rohan might have a totally different view to MIT, who work in this area too, to the Singapore authorities. MIT worked in Singapore. There's a wonderful presentation on their website about visualizing big data, mobile data. When it rains, for example, what happens? What happens to taxi movements? So actually there are no standards on anonymization that are being deployed that I'm aware of, and that's one of the challenges that we need to have, and what conditions apply.
Any other comments? Alex?
To go back to a comment that was made about confusing privacy and data protection, I appreciate that there is a difference, and there's a difference in the debate. The point I wanted to make is, because of the way that data is used and the power that data has to give an insight on people's private lives, their communications, the way they engage in society, if there's a failure to protect that data, that can lead to and interfere with the right to privacy. So that's where we make the connection.
Any other comments? All right, Rohan.
Very briefly, I think that the time now is for innovation. it is not for global standardization. Somebody trying to set global one-size-all-fits rules at this time is going to be deadly. We have to allow this process to go on for a little while, look at what is feasible, what is practical in particular contexts, then codify it, not top-down globalized standards.
Well, I'm walking to the back here to get your next question. Let me ask one as well. We've been talking a lot about big data and the challenges and the tremendous opportunities associated with that. I would note that in the United States, there was a report out of the White House that John Podesta helped work on and draft together with PCAST. And he said that the consent piece should be done probably at the back end rather than the front end because of the unknown areas of how it would be used. Let me ask, that's one extreme. On the other extreme, though, is individual information. I don't know if this is true. I tried to test it. That you could go onto Google and put your phone number in, and you could actually see where you have been at over the past some period of time. Now, unfortunately for me, I have a BlackBerry phone which provides no information about anything to anybody, so I couldn't tell if that worked. Is that something that's actually true?
I do know that if you are signed in and you put in your phone numbers, you can definitely at least identify where what information has been shared currently with us, but it's only as far as you have allowed it as an end user.
So it's not open to the public then?
As far as I know, no, it is not. Except somebody, and we do have people like that or institutions like that that have really good skills and can do that as some other work, but certainly not as Google.
Question in the back? It should be on.
Does it work? Yeah. Malte Spitz my name. I visualized my mobile phone metadata and put it online. And I'm always asking myself, why does the CDR has to have 32 different fields of information? Like when we talk about strengthening privacy, I think we have to talk about the amount of information that are there at the beginning. So I think we should talk about systems how to lower the amount of metadata that are necessary, because then we also lower the amount of information that can be shared with states and also can be used by the companies itself. And I always don't know why do all these different fields have to be there. I think this is a system from the past, and I think we have to talk about a system of data minimization here.
Thank you very much for that question. Pat?
Okay, so yes, in a call data record, there can be significant pieces of metadata. It's quite detailed and it's quite complex, and that's born out of, you're quite correct about the fact that networks need to know where your device is in order that they can ensure your device connects to the network. Some of the data in there just gives you a network error code, for example. I know because I used to have to go to court and explain these things. And some of that's important. When you have a customer who calls up and says, I can't understand why my call keeps dropping, or I tried to call X and it didn't seem to connect, I just keep getting a dead ringtone. This information is really important in helping you resolve your customer queries. And it is not the case that mobile operators retain that data forever. In fact, one company I work for, they would keep that in a live form for 90 days before it was then anonymized. Because you need that. Could you imagine a customer calls up and says, why does this keep happening? So we'd love to tell you, but for privacy reasons, we've anonymized and deleted all your data. And actually, operators also have other obligations to provide services and quality of services. And customers want to know. Sometimes customers want to know, well, why have I been charged this extra money for these extra gigabytes? So data really is important. But you're right, there needs to be an approach which looks at and ensures that each of those pieces of metadata are tagged in a way that they begin to drop off and become erased when they're no longer needed for these commonly accepted purposes, or where they're otherwise required to retain the data for under data retention legislation, for example.
Yeah, maybe to comment on that as well. Like Pat was saying at the end, it's important that every piece of information is regulate in how the way that each piece of information is used is regulated and known by the user as well, why certain pieces of information are requested. The danger that I was mentioning earlier is with this amassment of metadata, can you really control how that information, each piece of information used, if it's correlated with others? So that's one point. I think the other point I wanted to make is, Pat was mentioning improving services in the way when you use your device. But the point that's important to make as well is you're all the time, whether you're using your data or not, you're connecting to wireless system. That means that even when you're not using your mobile phone, you can be traced, and that's something to think about as well.
Yeah. Any other comments from the floor or questions from the floor? Let me ask sort of a basic question. We have operated on the assumption that privacy is extraordinarily important to consumers, that trust is the central focus here. We have survey data from the GSMA that would support that. But yet, as a couple of comments have indicated from the floor and elsewhere, if you look at the way in which consumers and customers operate, it may not support that. People seem to click immediately on through the endlessly long series of waivers and informed consent. Even if it were shorter, it's not clear, to, at least to me, that people would not click through, because they usually want that service, and if you don't click, you're not going to get that service that is of value. What makes us think that there's a real issue here? Do we see lack of adoption? Do we see competition where companies are saying, come to me, and are being much more successful by their privacy attributes? Do we have something other than the fact that people say probably the obvious, that yes, privacy is important, but not necessarily because there comes at a cost? Alex? Nope.
We would never argue that is the fault of the user. I mean, that is not the starting point we have. And I think consumers and users in general are being more aware of the pricing implications. I think there's still a lack of knowledge, though, in terms of what the power of data and what can come out of the use of their data. And that's something that we're working on across the world, and not just in developing countries. There's this assumption that in developing countries people have less knowledge of these things than in the West. And so yeah, that's something that's really important. And in terms of the privacy policies, and that's something as well that the message that we're trying to put across to industries, and it's the same argument with the laws, these policies need to be accessible to people. And it is about just clicking and not realizing what it means. But that's something as well that falls on industry to take into account.
Any other comments? Sunil?
I've often heard the argument that the sharing economy tells us that users don't value privacy. Look at the extent to which they share information, and look at the extent to which they allow these platforms to harvest personal information. But if this were completely true, then in the sharing economy, users would be constantly posting their passwords and saying, here's the password to my Facebook account, and here's the password to my Twitter account. So they obviously don't. There's some line somewhere. That line varies based on a variety of circumstances, but that line does exist. And to perhaps take it to another domain, such as the regulation of food, consumers love fast food. They are perhaps aware of the implications it has for their health, just as many consumers love tobacco, and the variety of things that consumers do. But when the provision of fast food or cigarettes happens through large corporations, and the potential for harm is large, then even if consumers don't understand all the regulatory complexity, it is the business of the state to uphold public interest and to mitigate harm to human rights by ensuring that it is appropriately regulated. Thank you.
Pat, you look like you want to jump in.
Well, I think there's a lot of research that also shows that it is a barrier to engagement. People don't download apps or engage with services when they discover that their privacy has been infringed in some way, that when their expectations have not been met. I think there's an assumption on the many parts of consumers that they can trust some organizations. It's not until they discover certain things that that trust becomes eroded and acts as a barrier. I'm not going to mention the name of the OS, but there's an OS that some of you have in your pocket now. And if you go into settings and privacy and location, you'll find a little thing, and everybody loves this thing because you can switch on and off your location. It's wonderful, great privacy enhancing capability. But if you scroll all the way down to the bottom of that screen, you'll find something called system services, a new category introduced some years ago on one of its iterations of its OS, and it has defaulted you in to be automatically tracked for 8 uses of your location data. And at about 2,500 words in of the 18,000 word privacy policy, you will find that the moment you switch on location services, you are expressly consenting to the use of your data for these other purposes. Now, a number of those are legitimate, you could ask, because if you want your device to set the date and time automatically based on the network you're connected to, that's great. But there are other things in there to support its vehicle navigation systems and its advertising systems. So one must ask them what kind of consent. Now, whenever you, and there are 800 million of these devices, by the way, so that's a lot of big data. But when you show and take people through this process, they go, oh my goodness, I didn't realize. And they switch things off, or they say, well, that should have been my choice. So actually, it does matter, and it is a barrier to engagement.
Do we have, Sunil raised this, I think, a little bit earlier, in his example about friendship. Are these issues truly universal, or do we see some significant differences regionally, culturally? One, of course, that's sort of famous and has been with us in this discussion for a long time is age. The young are very quick to give up their privacy. The older you are, perhaps the more experienced you are, it seems you're less likely to give up your privacy and some of those interests. How universal is this, and is it one size fits all? And if not, how tailored should this be?
I'm just going to come in really quickly with a bit of a practical example, and I'm not wearing my Google hat now. I'm a Nigerian by birth, and I did an informal survey really recently on the Boko Haram issue, and I asked a very wide range of end users that if you had the choice to give up some of your privacy, some of your data, for the terrorist to be located by government, what would your choice be? And I was very impressed, I don't know whether positively or negatively, to identify that from the most highly educated and aware of the implications of giving up your data and of allowing government to be able to survey or to be able to follow you, every single person said, yes, take away some of my freedoms, just get rid of this threat. And I think sometimes we're not, as industry, as government, we're not very aware that people are willing to give up a bit more to be able to feel safer. So it's then finding that balance again. I think it always goes back to that, finding that balance between freedom and responsibility at any point in time. Wearing the Google hat back on really quickly is, in as much as there's a lot of choices and complexities around these mobile phones, the ones who are usually able to afford the really complex devices with the very long terms of service, etc., are the ones who usually should be a bit more aware of the rights they give up. And I'm going to end with saying this again, that without laying fault at the end users, at the foot of the end user, we as industry certainly need to do more to make them aware of what they are consented to, 100%. But at the end of the day, responsibility.
So, very hard for us either to formulate policy or to configure technology that allows for this movement or this sudden transition from somebody that wants to divulge personal information to now somebody who wants to conserve personal information. But this argument of cultural relativism, unfortunately, is used by those that don't want to be regulated to delay regulation. And what we have done through historical research is identified privacy norms in Vedic law, Islamic law, pre-colonial law in India. So it isn't as if there is that much diversity that we can't somehow implement universal principles like necessary and proportionate. There are some things that seem to transcend all contexts, but there is also a huge difference even within a single country, within religious groups, etc. So the configuration is a multi-layered regulatory system. There is self-regulation, there is co-regulation, and even when it comes to regulation by the state, ideally the law is high level, mostly focusing on the principles, but then you have the office of the regulator that hopefully can examine each case and then give guidance on an ongoing basis. So what we don't want is overly engineered privacy law which prevents us from addressing the relativism question.
Very good. Well, let me ask sort of a follow-up, if I could, from what Sunil was just talking about. How do you all view the role of government and intergovernmental organizations in this space? Pat, you referenced early on in our discussion the fact that there's no single place for all of the relevant governmental interests to come together. Telco regulators, those who are involved in privacy-related issues within governments, those who do national security within governments, to come together globally to have these discussions about the trade-offs, the opportunities and the potential harms. Is this a space, do you all believe, that each country needs to regulate? Does each country need to call for self-regulation? Or is this an area for which we need global standards? Pat?
Well, to take Rohan's point earlier, I'm not calling for global standards, but we can certainly have no, I didn't. We can also we can have interoperability, and when, like as Amos said, when you're a Pan-Asian operator, Rohan, then it's important that you have some consistency to drive efficiencies, and some of that comes from standardized approaches to how you anonymize this data. And after all, the data belongs to their customers, whom they need to have trust in. I think, David, yes, there is a need to bring those together. I'm not sure which is the right forum, though, but I will give it some more thought.
I think there's another sort of quite interesting angle to this, because I think the concept of engagement with, the legal environment that you live in at any given time, the country, is relative to age. So the attention economy, which is a very nice way of putting it, the young ones are busy trying to get on, and they tend to give things away pretty easily. And then as you sort of settle down a little bit, get a bit older, you tend to accept the environment you're in and potentially some of those laws, and start making decisions about your government identity number, those sorts of things. They're persistent pretty much, and perhaps those are the ones that would be a good baseline. And the free-for-all happens sort of further up the chain, perhaps. Where the problem is, I have never given my passport number away so freely as in Asia. It's quite extraordinary how often you need to give it away. I've never taken my passport out in the UK. Over here, you need to give your passport number almost for any transaction. In which case, that passport number is held by all sorts of different organisations that shouldn't necessarily have it. But perhaps that's where the differentiator is between the type of data.
Very good. We've come to the end of our session. Let me ask if there are any other comments from our panelists on this or Any other subjects before we close? Alex? Oh.
To respond to a comment that was made about security, sacrificing some of our freedoms and rights to get security. Or the problem at the moment in the environment that we have is that now we're giving up all of our freedoms and all of our rights for a sense of feeling secure that's not even guaranteed. And that's definitely a problem that we need to start addressing, because people are living under the assumption that if they give up their rights, then they'll get security. But that's not the case at the moment.
Any other comments?
I just wanted to be able to end again with clearly stating the fact that freedom comes with responsibility. And being able to find that balance can only be achieved if every person, and I'm doing my very best not to mention that word, if every player, so Sunil is the only guilty one in this space. If every player, if every from industry, from government, the end users, civil society, technical community is able to better understand the driving force of the other end and why they take the positions they take. I think on our part as Google, we have taken it as top of mind to improve the technical capability to find that balance, and to also, I want to be able to use the word aggressively ensure that our end users are very much knowledgeable and aware of the technologies available to them.
Very good. Let me sum up, I think, very briefly by saying that once again we've established that this is an extraordinarily important subject. It's very rich. It's changing rapidly. The big data discussion is fundamentally different and new as compared to when we started this discussion. The mobility aspects of it make everything that much more complicated, and to a large extent that much more personal for each and every one of us. I think we've accomplished one of the great goals of the IGF in terms of process reform. We've been able to have remote access work correctly for the first time, I believe, in one of our sessions, and that's a major accomplishment. I want to thank the GSMA for putting this panel together. It was a terrific panel. Pat, thank you, and Giannis, thank you very much for all of your efforts in doing that. And I think we should give a round of applause to our terrific panel. Thank you very much. Once again, well done. Terrific, well done.
Well, I hope you paid for your flights. At least. Oh, fantastic. Always beautiful. Well, look, so you're going to be in Mauritius. I'll definitely come to email the commission today. In fact, some of the stuff like that. Before we ever do it, we're going to check the levels of price. You're doing it hopefully, I'm also doing it. But you and I both know. I know, because all the time.